All right, so we're on the record in docket 2402-180. That is the City of Lansing versus Emily Biddle. Will the parties please introduce themselves for the record? Mr. Gehring.
Thank you, Judge. Good morning. Joel Gehring, appearing on behalf of the City of Lansing.
Mr. Lee.
Assistant Public Defender John Lee, appearing on behalf of Emily Arteal Biddle.
And ma'am, you are Emily Biddle, is that correct?
Emily Biddle.
Emily Biddle. All right, thank you. This is the time set for a pretrial in the matter. Mr. Gehring, how we proceed?
Thank you, Your Honor. We have reached an agreement where we will reduce the charge to a breach of the peace civil infraction.
And Mr. Lee, you'll be accepting responsibility to the civil infraction on that matter?
Yes, Your Honor.
And I believe that it's $135
I think it's 150.
or 150.
It's 150.
150. Okay. All right. So it's $100, $150 civil infraction. And is that a fair statement, Ms. Biddle? You'll be through Mr. Lee, your attorney, you'll be admitting responsibility to the $150 civil infraction, and the misdemeanor is going to be dismissed. Is that correct? All right. So we'll amend it. Amend count 1, 2, breach of the peace. All right, just so we're working from the same ticket, Mr. Lee, this is ticket 245-190-6954 and involving conduct on July 20th of 2024. And you admit responsibility for your client, Emily Biddle, being, excuse me, on 1215 East Michigan, North Pennsylvania, being in breach of the peace on that date. Is that correct?
That is correct, Your Honor.
That comes with a $150 fine. Count with the $150 fine. Does your client need some time to make that payment to the City of Lansing?
Yes, Your Honor. Given her current situation, she is requesting 60 days to pay in full.
All right. So let's get a date 60 days out. October 7th. That would be Monday at 4. So, Ms. Biddle, how this works is you have October 7th to pay up the entire amount. You can make your own plan, pay as you go along the way, as long as it's all paid by October 7th. All right, ma'am? All right. Anything else for the record in docket 2402-180, Mr. Gehring?
Nothing, Your Honor. Thank you.
Mr. Lee?
Nothing further, Your
All
Honor.
right, Ms. Biddle, you're all set. Thank you for your appearance today.
Do you want to give her anything?
Yeah. So, Mr. Woolley, you're here on Mr. Simmons, Shane Simmons, is that correct? Oh, Mr. Woolley, Mr. Woolley's here on his own case.
Mr. Willie's Attorney Barlanga is here.
All right.
For Mr. Willie, correct.
So let's go on that case. That's the case we're talking about. We're ready to go on that.
Yeah, we would be ready to go on that while Mr. Lee is out of the room.
All right, so we're on the record in docket 24L2880121. That is the City of Lansing versus Andrew Wally. Will the parties please introduce themselves for the record? Mr. Garrett.
Good morning, Your Honor. Joel Gehring on behalf of the city.
And Mr.
Pedro
Berlanga.
Your Honor, Pedro Berlanga on behalf of Mr. Woolley. He's on Zoom.
Thank you. And sir, you are Andrew Woolley, is that correct?
That's correct.
All right, you can hear me all right, Mr. Woolley?
Yes.
All right, thank you. This is the time set for a formal hearing in the matter. Mr. Gehring, how are we proceeding?
Your Honor, we have agreed to amend this charge to an impeding traffic.
And that's a civil infraction of impeding traffic.
Yeah, you're on a $130 fine.
Impeding traffic. That's 135 now, right?
Oh, has that gone up?
It's 135. It was 130.
Oh, the new, yeah.
Yeah.
Thank
so.
you.
All right, Mr. Berlanga, is that your understanding? Your client, through you, you'll be admitting responsibility for the impeding traffic and the $135 fine. And we'll amend the speeding ticket to reflect that. Is that correct?
That is all accurate, Your Honor.
All right. I'm going to bring your attention to, so we're working from the same ticket. That's ticket L288012 for conduct that occurred on July 6, 2024 at Grand River Marshall Street in the city of Lansing, Ingham County. Do you admit responsibility for Mr. Woolley impeding traffic on that date?
Yes, Your Honor, I admit responsibility on his behalf.
All right, thank you. That comes with a $135 fine. Does your client wish some time to make that payment to the city of Lansing?
Your Honor, I'll defer to Mr. Woolley. Mr. Woolley, how long would you need to pay that?
I can have that paid by the end of the month.
All right, by the end of the week, sir?
End of the month, Judge. Could we get a month?
Sure. So I'm going to set payment of the $135 to the city of Lansing. Will be by Friday, August 30th.
Perfect. Thank you, Judge.
All right. All right, so Mr. Woolley, you'll have till Friday, August 30th to pay off the $135 fine to the city of Lansing. You could make that incrementally, or you could pay it all at once, as long as it's all paid by the 30th. And you can pay online, in person, or by phone. All right, sir.
Okay. Thank you.
If you pay by online, just go and find the 54A criminal court website, and you can pay there. All right, sir.
All right. Thanks.
All right. Anything else for the record in 24L2880121, Mr. Gehring?
Nothing from the city, Your Honor.
Mr. Berlanga?
Nothing further, Your Honor.
All right, Mr. Woolley, you're all set. Thank you for your appearance today.
Thank you.
Thank you, Mr. Gehring. Thank you, Your Honor.
You bet.
Thank you.
Thank you, sir.
Judge, there's been a Moto G Pure sitting in the waiting room. I tried to get them to identify themselves like 3 times, and I even messaged them. I don't know if you want me to admit them still.
Simmons just asked for help. He's in the breakout room. I'm not going to join the breakout room because I think that puts the whole courtroom.
It does.
But I've done that. I learned by failure that this courtroom's not supposed to be in a breakout room. All right, so the Moto G, are they even on anymore?
They're in the
they're
waiting room.
Let's see if we can identify them, and then we'll call the next case.
You might not even be aware that that's what they're identified
Yeah.
as, and that you
Yeah,
mean them.
that's
Yeah. Well, I messaged them in the the waiting room.
All right.
Well, that should come in. A DM should be clear enough.
on the Moto G Pure cell phone. You just joined the room. Can you unmute yourself and identify yourself? On the cell phone that just joined the room, can you unmute yourself and identify yourself? I'm just taking.
Ronald Axline.
Okay. What's your name?
Ronald Axline.
Ronald Axline. You're here for your 9:30, sir?
Yes, sir.
All right. Stand by. You're in the right place. We'll call your case in a few minutes. All right.
Okay, thank you.
You're welcome. And you might want to mute so because the Zoom courtroom can hear you.
Okay, I got lung cancer, so I'm trying to.
All right. Or keep it silent, keep it quiet, because we can all hear what you're saying.
Okay, will you mute it? I'll be coughing.
All right. So Mr. Lee is in with Mr. Simmons. All right, Mr. Garlinghouse, you're here on Stoneridge Meadows.
Yes, Your Honor.
All right, I'm gonna pull that up. It's updating right now. And then we'll see who's here. That's at 10 o'clock, correct?
It is, yeah, and we do
All
have a
right.
resolution.
All right,
That's why we said it. We are pending a resolution.
all right. And are we waiting on Mr. Alexander, Miss Alexander and Mr. Whittington?
Yes, Your Honor. They should
All
be
right.
appearing any minute.
All right, we'll call that in a little bit. We've got some other criminal stuff to call in front of that, but when everybody gets here, we'll put that on the record.
Perfect. Thank you, Your Honor.
Thanks.
You better look at it, because I don't know what to do.
I don't know. Oh, Shane Simmons, that somebody is. When it's you, I guess.
Mhm.
Ma'am, listed as David Glenn. Can you identify yourself? You have the moniker
Vicky
David Glenn.
Alexander.
What's your name, ma'am?
Yeah, that's my computer, so I,
All right.
Vicky
What's
Alexander.
all right? So, Mr. Garlinghouse, that's Miss Alexander from your
Yes, Your Honor.
case. All right. All right. Stand by. Mr. Lauderdale, you're here on your show cause at 11. You have to unmute.
I'm gonna let her
Are you
out.
talking to me?
No.
I
Yes,
am
sir.
not, ma'am.
Case.
Yes, sir.
Okay.
Yes, Judge.
All right. Stand by.
I think we may have to change our plan.
Yeah.
If you pay this, you'll have a judgment
Mm-hmm.
on your credit rating.
Mm-hmm.
Mr. Garlinghouse, we're ready on your case. Do you, Miss Alexander, are you here with Joseph or Jason Alexander?
No, we didn't know he had to be here. He's, my son
All
is
right.
disabled.
All right. And then the third is Joseph Whittington.
That's Jason's caregiver.
All right. So, Mr. Garlinghouse, are you ready to go on that?
Yes, Your Honor.
All right. Let's go ahead and call that case. All right. All right, so we're on the record in docket 24-02100. That is Stoneridge, Meadows versus Jason Alexander, Vicky Alexander, and Joseph Whittington. Appearances for the record, Mr. Garlinghouse.
Yes, good morning, Your Honor. Nicholas Garlinghouse, P number 72150 on behalf of plaintiff, and representative of Stoneridge Meadows, Ms. Elena Blackwell, is also present under Mulder
Thank you.
management.
Thank you. And then, ma'am, your appearance for the record.
Elena Blackwell.
All right. And then, ma'am, you are Vicky Alexander, is that correct?
Correct.
All right. And Mr. Garlinghouse, are you waiving the appearance of Joseph Whittington and Jason Alexander? It appears that they're not here today.
Yes, Your Honor. As Ms. Alexander described, her son is disabled and Mr. Whittington is his caregiver. They've appeared at the other two hearings, and I don't believe their appearance is necessary here today.
All right. Let me make a note of that just so that if there's any right, this is the time set for a hearing on the non-payment case. Mr. Garlinghouse, how are we proceeding today?
Your Honor, I believe we have terms for a conditional dismissal in this case. I spoke with, well, Mr. Glenn on behalf of Ms. Alexander, which again, I'll object to him acting as an attorney since he's not an attorney. But the terms that we came to were that Ms. Alexander will make a payment of $1,710 to satisfy the balance in full by this Friday, the 9th.
$1,700 she has to pay?
Ms. Morhart, Morhart, you should mute. I don't know if you're on this case that we just called.
She is not.
So you should mute.
My bad, sorry.
All right, thank you. Go ahead, Mr. Garlinghouse.
Okay. Sorry, again, Your Honor. Ms. Alexander has agreed to pay $1,710 in satisfaction in full of the balance owing, and my clients will write off the remaining balance as long as that is received by the 9th of this month. So that is this Friday. As long as that is done, the case will remain dismissed. If that payment is not received, then judgment may enter at that time and without further notice to the defendant or any further proceedings from the court.
All right, and Ms. Alexander, that is your understanding of the conditional dismissal?
Yes,
All right, you understand that you have 3 days from today's date to indicate or to file a motion saying that that something we did here was ambiguous or you didn't understand it because you're not represented by counsel.
yes,
Is that a yes, ma'am?
yes,
Okay, that's kind of your protection that you weren't represented by counsel. So you have 3 days to say that something we did here was ambiguous. All right,
okay,
Mr. Garlinghouse, you're going to follow that up with a conditional dismissal, the order to that effect?
Correct, Your Honor. And Ms. Alexander, do I have your permission to sign your name to that form when I submit it to the court?
yes,
Okay, and I'll
Yes.
I'll send you a copy of it by email as well. And then the court will
Please.
send it out once it's signed.
please,
All right.
please.
All right,
All
thank
right,
you, Your Honor.
so the conditional terms have been placed on the record. The court rules explained to Ms. Alexander, and Mr. Garlinghouse is going to follow up with a conditional dismissal order, and authorization has been given to sign the order. Anything else? So I will await the order, Mr. Garlinghouse. Anything else for the record in 24-02-100?
Nothing further for me, Your Honor. I'll get that submitted on my file right away.
All right, thank you. Ms. Alexander, do you have any questions of me?
I have no questions, no.
All right, ma'am. All right, well, thank you for your appearance today. Thank you from Older Management for your appearance today.
Thank you, Your Honor. Have a good day.
You too.
Thank you, Your Honor.
Thank you.
Thank you.
All right, Mr. Lee, do you know where you want to put him, Megan?
I just put him in room 2 with
All right.
Mr.
All right, Mr. Lauderdale, we can call your case. All right, so we're on the record in docket 24 L2841341. That's the City of Lansing versus Dwayne Lauderdale. For the Mr. Lauderdale, your appearance for the record.
Yes, sir.
All right, this is the time set for a show cause. There's an outstanding balance. Is that $130? 120. There's an outstanding balance of $120 on this account to the city of Lansing. That's why the show cause cycle has started in this, and a warrant was issued, a show cause was issued. Mr. Lauderdale, do you need some, we initially set it up for June 20th at 4, and then we set the show cause on August 6th. Do you need some time to pay that $120 debt and get out of this show cause cycle? Because this is what will continue to happen if the payment's not received from the city of Lansing.
Yes, sir. I can make a payment on Monday, sir.
What about, you have $120? So how much of a payment can you make on Monday?
I'll pay the whole
you
thing,
pay the
sir.
whole.
Yep.
All right. Well, let's give you we'll give you a week from today, okay? So that'll be Tuesday the 13th at 4.
Okay. I apologize for the inconvenience.
No, that's all right. So all right. So D is to make payments by August 13th. At 4 o'clock. That would be $120 to the city of Lansing. That can be made online, in person, or by phone. It can be made here on the 6th floor City Hall, or you can pay that online, and that should be made on August 13th before August 13th at 4 o'clock. And then we'll make sure you've answered the show cause so no warrant is issued for you. All right, sir?
Thank you, sir. Appreciate you.
All right. So we should be all set. Make sure, and to stay out of the show cause system, make sure you make that payment by August 13th at 4. All right, all right, sir?
Yes, sir. Thank you.
You're all set, Mr. Lauderdale. Thank you for your appearance.
Thank you.
Miss Morehart, I have you under Faith Morehart.
Yes, sir.
What case are you here on?
It's a Summit of landlord tenant, I guess, and it's 240408 ALT.
I'm thinking that's tomorrow, but let me double check.
Because it's oh shoot, it is tomorrow. My fault. I got the wrong date.
She has more.
And ma'am, yeah, you have the wrong date. You should contact the city of Lansing. You might have other stuff going on with the city of Lansing. All right.
All right. So ours is tomorrow at 10, right?
Yeah. I don't know. It's set tomorrow at. Let me look it up.
Yes, at 10.
At 10. That's set tomorrow at 10 o'clock. You also should contact the criminal department of the city of Lansing. You might have some other stuff going on that you want to clear up.
All righty. Thank you.
You're welcome. Mr. Lee, did you want to meet with anyone, or are you ready? What are you ready to go on?
Your Honor, I do need to meet with Mr. Axline, and if that is Mr. Erens in the jail, then I'd need to meet with him as well. We are prepared to proceed on Simmons and Jay Sean Hill.
All right.
Mr. Axline's just not joining the breakout room is all.
All right. So we've placed you in a breakout room with Mr. Axline, but he's not joining the breakout room. I can put you in a room with the post number 1, which is Mr. Erens, and then we'll go on the ones that we were ready on. But I'm going to put you in a breakout room. I'm going to move you to room 3, and then I'll put Mr. Erens in room 3, and then we'll call those cases when they're ready.
No, Axline just joined.
Okay. All right. So this one is going to room 3, Mr. Lee. And then And then Axline just join the room.
Of course.
The beauty of Zoom.
Gotta love it.
No, on Monday it says Judge Italian PCCs, we shall hear.
Good luck with that.
Yep. Welcome to my world next week. I did let them know whatever was left down for exam next week. We can judge it.
Okay. We'll see what those numbers.
I left a few extra reset dates for whomever's covering.
Doesn't it? Yeah, it doesn't.
Prosecutors like it left out, defense is gonna not want it.
So you, Megan, you did get your. sorry. Mr. Lee, I'm gonna put you in with Mr. Axline if you're done.
That would be fine, Your Honor. I have not completed a discussion with Mr. Simmons. I wanted to update the court. He's having technical difficulties on his end with his microphone. We can't hear anything he's saying. So, maybe I would leave Mr. Simmons in his room and maybe put me in a different room with Mr. Axline, and then I can
All
bounce.
right, but Mr. Axline's in room 2.
Okay.
Mr. Simmons is now in the regular courtroom.
Oh, okay.
So let me put you in room 2 and then tell me if you're having trouble. I'm gonna move. Yeah, I gave Mr. Axline his own room. You'll get a prompt to go to room 2 and we'll see if that works.
Okay.
Mr. Simmons, can you hear me? I'm gonna have you unmute. Shane Simmons. Mr. Simmons, are you there? All right, are you Michael Erens? Is that a yes, sir? Can't hear him. Yeah, your attorney is in a breakout room at this point. So go ahead and stand by, but you're in the right place if you're Michael Erens. All right. All right, Mr. Lee, I have Mr. Simmons in another room. Are you all set with Mr. Axline?
I'm all set with Mr. Axline. Yeah.
I put if you want to try to complete your meeting with Mr. Simmons, I can move you to that room.
Okay. I've actually met with Mr. Simmons. It's Mr. Erens that I'm concerned about.
All right.
I couldn't hear
So
him
let
when
me-
we were meeting before, yeah.
Yeah.
Oh,
So let me put Mr. Erens in your room where you're at now, okay?
Okay, that sounds good.
Whatever.
All right, and then when Mr. Lee's done with Mr. Erens, we'll start calling the cases.
Wow.
And I didn't know that there was a map. Charge. Yeah, but there's no phone service. So I run it off the internet, you know. I don't think I can go to the Play Store and download the app without phone service.
Right, so we're on the record in docket 21-00729. That is City of Lansing versus Jashawn Hill. Will the parties please introduce themselves for the record? Mr. Gehring.
Thank you, Your Honor. Joel Gehring, appearing on behalf of the city.
Mr. Lee.
Assistant Public Defender John Lee, appearing on behalf of Jay Sean Hill.
And sir, you are Jay Sean Hill, is that correct?
Yes.
Thank you. This is the time set for a pretrial in the matter. Mr. Gehring, how are we proceeding?
Well, Your Honor, this was originally a driving while unlicensed matter. Mr. Hill has since rectified that situation. His license is now valid, and the city is willing to dismiss this at this time.
And that's a fair statement, Mr. Lee?
Yes, Your Honor.
Compliance attained. This will be dismissed.
Yeah, that was the words out.
I believe this is is this on a ticket? All right. So with that understanding, the misdemeanor has been dismissed for compliance purposes. It's dismissed without prejudice, Mr. Hill, which means that people could reissue if they choose to, but realistically today, the case is dismissed. All right, sir? Anything else for the record in 21-00729, Mr. Gehring?
Nothing, Your Honor.
Mr. Lee?
Nothing further.
All right, Mr. Hill, you're all set. Thank you for your appearance today. And where did you want to go online?
Sure. I think we can do Mr. Simmons, Your Honor.
All right. Right, so we're on the record in docket 24-01777 and 24-01778. That is the City of Lansing versus Shane Simmons. Will the parties please introduce themselves for the record? Mr. Gehring.
Joel Gehring on behalf of the city.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Shane Simmons.
And sir, you are Shane Simmons, is that correct?
Yes, sir, I am.
All right. And you can hear me all right, Mr. Simmons?
Yes, I can hear you. Can you hear me?
I can, thank you. This
Okay,
is the time. This is the time set for a pretrial on both matters. Mr. Gehring, how are we proceeding?
Well, Your Honor, I'm going to go ahead and defer to Mr. Lee for a request from you.
All right, Mr. Lee.
Your Honor, Mr. Simmons reports that he's got a matter in Eaton County that he believes once sorted out will make it a big difference in his ability to get his license reinstated. He's got a hearing set in Eaton County on August 28th. So we're asking for a 30-day adjournment to allow for compliance.
All right. So adjournment for compliance purposes. And you said the hearing was August 28th in Eaton County, is that correct?
That's correct, sir.
All right, so we'll do it post August 28th.
September 3rd at 9 a.m.
So let's set it for September 3rd at 9 a.m. Which would give us at least some information on where this is going. So we'll reset for compliance purposes this hearing on September 3rd at 9 a.m. Anything else for the record in 2401-777 or 778, Mr. Gehring?
Nothing for the city, Your Honor.
Mr. Lee.
Nothing further, Your Honor.
All right, Mr. Simmons, we'll see you back here on September 3rd. All right, sir?
Okay, thank you very much.
You're welcome. You're all set.
Okay, thank you. Bye-bye.
On we have Price and Wilson-Concade. I don't know if they're here or not.
Wilson-Concade, I believe, is.
We do that already?
I haven't seen them, Your Honor, but
Let's say those for the end.
I was
Okay.
going to say the city office is going to dismiss his case if the court would entertain the possibility of waiving his appearance.
Yeah, I don't.
Siobhan
So-
Wilson is on Zoom.
And Wilson.
Oh, is he? Oh, okay, great.
All right. So how about Erens? Erens has been.
Yeah, been patiently waiting,
All
Your
right,
Honor.
yeah. All right, so we're on the record in docket 2401-547 and the accompanying ticket of 24L2861992. That is the City of Lansing versus Michael Erens. Will the parties please introduce themselves for the record? Mr. Gehring.
Good morning, Your Honor. Joel Gehring, appearing on behalf of the city.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Michael Erens.
And sir, you are Michael Erens, is that correct?
Yes, sir.
All right, thank you. And you can hear me all right, Mr. Erens?
Yes, sir.
This is the time set for a pretrial on the matter. Mr. Gehring, how are we proceeding?
Well, Your Honor, this is, as you've indicated, two separate tickets. We've got a failure to display ops as well as a driving while license suspended. The city would be willing to dismiss its failure to display ops charge if there is a plea to the driving while license suspended charge. There's also a potential kiloboot agreement with respect to time served. We would have no problem with that. My understanding that he has served 10 days already. And I will defer to Mr. Lee with respect to fines and costs aspect.
All right, Mr. Lee. Is that offer being accepted today?
Yes, it is, Your Honor.
All right. So it'll be a plea to the charge on the driving while license suspended. And that is with a kilobrew of time served. And then a dismissal of the civil infraction. Is that correct, Mr. Gehring?
Correct, Your Honor. Actually, it would be a dismissal of the failure to display, which is also a misdemeanor.
Yeah. All right. Correct.
There were two civil infractions involved in both tickets, but those are not being handled through us today.
Right. Okay, dismiss for plea. All right. And so is that, so I'm going to restate the plea agreement as I understand it. For the record, it's a plea to the charge on file 24-01547, Killebrew of time served, and then a dismissal of 24L28619992 per the negotiations. That file is to be dismissed. Is there anything else concerning the plea agreement, Mr. Lee?
Nothing further, Your Honor.
All right. May I inquire of your client of his advice of rights on this misdemeanor?
Yes, you may, Your Honor.
All right. Now, Mr. Erens, you understand that the ultimate penalty you could face in the driving while license with the driving while license suspended plea is 90 days and or is it $100 or $300? $500? 90 days and or $500. There's a Killebrew agreement between the lawyers that you'd only do time served in this matter. If I was going to not follow that Killebrew agreement, you would have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sir.
All right. I'm going to walk you through your misdemeanor jury trial rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney John Lee, and he would be present to cross-examine any witnesses or contest any charges brought against you by the city of Lansing. You'd have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to any appeal issues from trial. Since you won't be having a trial, you'll be pleading guilty to 24-01547 or the driving while license suspended instead. Is it your intent today and your wish to plead guilty to driving while license suspended?
Yes, sir.
All right. And if you raise your right hand, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Yeah, I'm going to bring your attention back to the. Just gotta find the ticket here. I'm going to bring your attention back to May 9, 2024 at South Pennsylvania Avenue and Vernon Avenue in the city of Lansing, Ingham County. Were you operating a motor vehicle on South Pennsylvania Avenue and Vernon Avenue on that May 9, 2024 date?
Yes, sir.
And at the time, was your license suspended, revoked, or denied?
Yes, sir.
All right. Anything towards a factual basis, Mr. Garrett?
Nothing else, Your Honor.
Mr. Lee?
No, Your Honor.
Find the factual basis to be knowing, voluntarily, and accurately made. Any objection to me following the Killebrew agreement and going to immediate sentencing?
Nothing from the city, Your Honor, other than I think Mr. Lee does have some question on fines.
All right. So, Mr. Lee, any objection to immediate sentencing, and do you have any allocution on fines and costs?
Yes, Your Honor. No objection to immediate sentencing. Allocution on fines and costs would just be the reason we entered into the credit for time served agreement, Your Honor, is because Mr. Erens does not have any funds and is currently incarcerated with a felony matter pending. It will be quite some time, perhaps even before he's released. So we would ask the court to consider a waiver of the fines and costs in this matter.
Thank you. I find that what's the pending felony matter? Just out of curiosity.
It is, I think it's a possession.
Okay.
Domestic.
All right. I will follow the Killebrew agreement, and with time served, the fines and costs on this are waived. I'll also waive the state fee and crime victims' right fee. Which means, so we can close this file. And so, Mr. Erens, you are completely done with these two files then, and then you have your other felony file to on your plate to address that, but you should be done with both your these misdemeanor files. All right, sir?
Yes, sir. Thank you.
All right. Anything else for the record in 24-01547, Mr. Gehring?
Nothing, Your Honor. Thank you.
All right, Mr. Lee.
Nothing further. Your Honor.
All right, we're all set on those files. Good luck to you, Mr. Erens. You're all set.
Thank you.
Do you want to go on Mr. Axline?
Yes, Your Honor.
All right, Mr. Axline, we'll call your case. We're on the record in 24L286147172.
Hello?
We're calling your case next, Mr. Axline, and 24L2861471. Will the parties please introduce themselves for the record? Mr. Gehring.
Thank you, Judge Attorney Joel Gehring, appearing on behalf of the city of Lansing.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee, appearing on behalf of Michael Thomas. I'm sorry.
And sir, you are Ronald Axline, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Axline?
I can't hear him.
Can you hear me all right, Mr. Axline?
Barely.
All right. This is the time set for a pretrial in the matter. Mr. Gehring, how are we proceeding?
As you know, Your Honor, we're looking at a failure to display as well as a seatbelt civil infraction. The city is willing to drop the failure to display operator's license as long as there is a plea to the seatbelt violation.
All right. Mr. Lee, is that your understanding of the offer?
That is my understanding, Your Honor.
And is Mr. Axline going to take that's a civil infraction, right?
Correct, the seatbelt is.
So Mr. Axline going to admit to the civil infraction today?
Yes, he is.
On your behalf, and you're going to take responsibility for him?
Yes, Your Honor.
All right. All right, so we'll dismiss. File 24L2861472.
What's this for? This is your judge.
Per negotiations. And then we will admit responsibility to the seatbelt civil infraction. And is that $135 fine?
What happened? What happened?
65. All right, perfect. And that's your understanding, Mr. Axline. You're gonna admit responsibility through your attorney, Mr. Lee. It comes with a $65 fine. Is that correct?
Yeah.
All right. All right. So, Mr. Lee, do you accept responsibility for Mr. Axline for ticket L2861447 on South Kings and Holmes in the city of Lansing County for operating a motor vehicle without a safety belt?
Yes, Your Honor.
All right. So that'll be a fine of $65 for the admission of responsibility. And does your client need some time to pay that?
Yes, he does, Your Honor.
All right. So, Mr. Axline, we'll give you 30 days to pay the $65 amount.
30 days.
That can be paid online.
Okay.
All right. That can be paid online, in person, or by phone, and you'll have 30 days to pay that $65, and that should be paid by September 5th. September 5th.
Okay.
All right. So with that understanding, anything else for the record on either one of the tickets, L2861472 or 71, Mr. Gehring?
Nothing for the city, Your Honor.
Mr. Lee?
Nothing for the defense.
Okay, Mr. Axline, you're all set. You have till September 5th to make the payment, $65 payment. All right, sir?
Okay.
All
Thank
right,
you.
you're all set. Thank you. And then, sir, are you Lauren Morris?
Yes, sir.
Did you want to talk to Mr. Morris, Mr. Lee?
Yes. Is Mr. Wilson-Concade on?
Yes.
Let's be prepared for him.
All
This
right,
is
let's
gonna
go
be-
on, Mr. Didn't see him then. All right. So, Mr. Morris, I'm going to place you in a breakout with Mr. Lee as soon as we get done with the next case. All right, sir?
Correct.
Right, so we're on record in 24L2874771. That is City of Lansing versus Trayvon Wilson-Concade. Will the parties please introduce themselves to the record? Mr. Gearing.
Attorney Joel Gehring on behalf of the city, Your Honor.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Trayvon Wilson-Concade.
And sir, you are Trayvon Wilson-Concade, is that correct?
Yes.
All right. And you can hear me all right, Mr. Wilson-Concade?
Yes, sir.
All right, this is the time set for a pretrial in the matter. Mr. Gearing, how are we proceeding?
Thank you, Judge. As you know, this was a driving on a suspended license situation. He has verified that his license is now valid. He's taken care of that issue, and the city is willing to dismiss this on the record.
Is that a fair statement, Mr. Lee?
Yes, Your Honor.
All right, Mr. Kincaid, for compliance purposes, the city moves to dismiss the ticket, the misdemeanor portion of the ticket. And so I'll dismiss without prejudice, which means the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, sir?
Okay, thank you.
All right. So for compliance purposes, the misdemeanor on the expired license is dismissed. Anything else for the record in 24L2874771, Mr. Gearing?
Nothing further, Your Honor.
Mr. Lee?
Nothing further.
All right, we're all set. Thank you for your appearance today, sir.
Thank you.
That's all right. And then Mr. Lee, I can, once you join, I can put you in with Mr. Miss Marciniak, what case are you here on? You'll have to unmute.
It is.
Miss Marciniak, what case are you
Yes.
here on? I don't have you on our docket.
Okay. It's 24L 2830481.
That sounds like a landlord.
No, that's a ticket. She has a bunch of tickets. Money on, but she's not for show cause today. I don't know.
She was one of those files I gave to Cody because
She
wasn't on the
paid
docket.
it. So she paid what she was scheduled for today, so she's all set, but she does still have some outstanding tickets that they will show
Alright.
cause her on.
So Miss Marciniak, we have you, you were not show cause today because you've paid all the tickets that you have with us. You may still have some outstanding tickets with the city of Lansing. You should check on that. But all our files you paid on. So you have no show cause hearing this morning.
Okay, thank you.
You're welcome.
She has 3 outstanding tickets that they haven't gotten show cause yet.
All right. Well, she'll know. All right, so we're on the record in docket 24-01842. That is the City of Lansing versus Lauren Morris. Will the parties please introduce themselves for the record? Mr. Gearing.
Thank you, Judge. Joel Gehring, appearing on behalf of the city.
Mr. Lee.
Assistant Public Defender John Lee, appearing on behalf of Lauren Morris.
And sir, you are Lauren Morris, is that correct?
Yes, sir.
You can hear me all right, Mr. Morris?
Yes, Your Honor.
All right, this is the time set for a pretrial in the matter. Mr. Gearing, how are we proceeding?
Well, Your Honor, this was a trespass incident that occurred. We have offered and I believe accepted on a Killebrew agreement with respect to time served. I believe Mr. Morris has served 14 days. So that's where we stand at this time.
Okay, so it's an offer plea discharge with the Killebrew of time served. Is that a fair statement? And that's your understanding, Mr. Morris?
Yes, Your Honor.
All right, you'll be pleading guilty to the trespass. That is punishable by 30 days in jail and or $100 fine. It's my understanding that the lawyers have agreed to a Killebrew of time served in this matter. If I was not going to follow that, you'd have the opportunity to withdraw your plea. Is that your understanding, Mr. Morris?
Yes, Your Honor.
All right. May I inquire of your client of his advice and rights on the misdemeanor case, Mr. Lee?
Yes, Your Honor.
All right. So, sir, you have the following rights in this misdemeanor case, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney John Lee, and he would be present at the trial to cross-examine any witnesses or contest any charges brought against you by the people of the City of Lansing. Do you understand that, sir?
Yes.
You also have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it your wish and intent today to plead guilty to trespass in this file?
Yes.
I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
I'm gonna bring your attention back to City of Lansing, East Michigan Avenue and Clifford Street. At that time on June 15, 2024, were you present on June 15, 2024 on East Michigan Avenue and Clifford Street in the City of Lansing?
Yes, Your Honor.
And at that time, did you trespass on property or remain on property without the authorization of the owner of the property?
Yes, Your Honor.
Did you trespass or did you remain on the property, sir?
I trespassed.
All right, thank you. Anything towards a factual basis, Mr. Gearing?
Nothing further, Your Honor.
Mr. Lee?
Nothing further, Your Honor.
I will follow the Killebrew time served. Is there any objection to immediate sentencing, Mr. Gearing?
There is not.
Mr. Lee?
No, Your Honor.
Killebrew the time served. Follow the Killebrew agreement. Mr. Lee, did you want to be heard on allocution on any fines and costs?
Yes, Your Honor. Thank you. Mr. Morris is homeless, which is why he has experienced a couple of these, or I should say, contributed to his experience in bringing about these charges. He will be incarcerated until the end of August in regard to a separate matter. So paying any fines and costs is going to be very difficult for him, Your Honor. We would ask the court to consider the waiver of fines and costs.
All right. Any comment, Mr. Gearing?
None, Your Honor.
I'm going to waive fines and costs in this matter. Do we know what the time served was on this?
I believe Mr. Lee indicated 14 days.
I'm going to waive fines and costs, and I'm going to waive the state fee and crime victims' rights fee, and we'll set time served at 14 days. Right, anything else for the record in docket 2401-842, Mr. Gearing?
Nothing for the city.
Mr. Lee?
No, Your Honor.
All right, Mr. Morris, you're all set. Thank you for your appearance. You're all done with this file.
Thank you, Your Honor.
You're welcome. Then did you want to call Ms. Price? The last one I have for is Andrika Price. And Mr. Lee, I don't know if you were on that case or not. I didn't originally have the public defender's office on that.
I do not show that we are the attorneys of record.
You do not show.
I do not show.
All right. All right. So let's go ahead and go on the record in docket 2401-080. That is City of Lansing versus Andrika Price. Appearances for the record, Mr. Gearing.
Joel Gehring on behalf of the city, Your Honor.
Right, this is the time set for pretrial. It was scheduled for 9 o'clock. It is now 11:22. And it would appear that defendant has failed to appear for pretrial. I've checked the Zoom courtroom, physical courtroom. There was nobody that name in the hallway. Ms. Price has not appeared since 9. How's the city proceeding, Mr. Gearing?
Well, Your Honor, I believe this is the first failure to appear, so I would leave it to your discretion.
I'll issue a bench warrant and bond forfeiture with a 48-hour hold.
Sounds good.
Anything else for the record in 2401-080, Mr. Gearing?
Nothing, Your Honor.
All right, we should be all set on that file. That's it, isn't it, for the morning?
I think it is.
I think we have some show causes, but I think that's
it for the two of us.
Yep. Well, thank you for your assistance today.
Thank you, sir.
We'll see. I mean, right now it's my gig, so yeah. So it'll just be you and me, I guess. Appreciate it. Yeah.
Which one call Shipley? You already done the. It's around the record and docket T01034641 and T0103463778. It's the City of Lansing versus Katrina Shipley. This is time set for show cause. It was set for 11 o'clock. It is now 11:24. I do not see a Ms. Shipley in the Zoom courtroom, physical courtroom. There's nobody by that name in the hallway. It would appear that the defendant has failed to appear for the show cause. This is for a show cause $76.80 and $130.80. And we'll issue a bench warrant and bond forfeiture for the fail to appear. And that's all for the record in T0103463778 and T0103464141. We can have give Ms. Callahan a few minutes. All right, so we're on the record in docket 23005061. You can have a seat right there. And this is a show cause hearing for, I think, an outstanding balance of $150 to the city of Lansing. So the city of Lansing still has you at $150 on the dog tickets.
Yes.
Yeah, and so, and this show cause hearing is because it hasn't been paid yet. Do you intend on paying that, or do you need some time to make that payment? And that'll get you out of the show cause cycle, because that's what you're in a show cause cycle right now.
So I probably need maybe like the third of the month I receive my check. So probably the 4 or 5.
Okay, so 30 days?
Yeah, 30 days is fine.
We'll do 6 weeks.
Okay.
So give me 6 weeks out. So we'll pay to the city of Lansing Friday, September 20th at 4 o'clock. Pay to the city of Lansing $150. So that you have till Friday, September 20th at 4 o'clock to make a payment, that $150 payment to the city of Lansing. So no warrants issued. You answered the show cause. If you don't, then it'll just keep going. You'll just be in the cycle. Okay. And so that's what you want to avoid. So $150 to the city of Lansing by Friday, September 20th, and you should be all set. Okay, sir? All right.
And if I have the money before.
You can pay it all off before then. Yep. It's all due by Friday, September 20th, but you can pay it all before if you have it.
Okay, sir.
All right. You're all set. Thank you.
You're gonna give me a paper?
Yeah, they're just gonna get the file, so they'll know that they'll know it's written on the file. So if you want to pay before that date, you can go to the front window.
Okay.
No?
Okay, thank you.
You're welcome.
Well, I don't know if you can give me a paper so I can see the.
Yeah, we'll print something out.
Please. Oh, I have everything
Right. So make sure Mr. Baka-Martinez has, or Martinez Baka has what's being printed out right there.
Of course.
You're all set. Thank you. You too. It's good for them. I mean, it's good to have something that. It seems silly to put him on a payment plan because I know once he gets the money.
Well, yeah. We knew that was happening. They got it done.
I was happy those cases were done. I had one woman just tell me I'm not paying. She was the one that she was put on her name on her brother's. She's like, I'm not gonna pay that because I'd actually. I mean, he's got to tell his sister no, and she's not at wallflower. She's going to be yelling at him, so that needs to be paid. Or he's got 6 months of yelling hearing from his sister about it. All right, the rest from Mr. Callahan. Ton of parking tickets.
She's great.
It's me.
Just you. What kind of car is this? Ford. (9:30 in the morning). Oh, they're even different different parking officers. This is for 10 o'clock in the morning. For 1:03 in the afternoon. For 9 a.m. So she pretty much just parks wherever she wants and
Seeing a pattern there.
yeah. Parking expired meter, expired meter, expired meter. And then she throws it on the floor because that's what they do in the movies.
Yep.
And she expects no consequences.
Today, one of my grandkids turns 40.
Goodness. Past the terrible twos.
Actually, JP was never terrible to.
No? Well, maybe he's make up for it with the 3.
I think he's gonna be a problem when he's 16.
That's Henry.
16 tends to.
The thing with JP is he's super independent and he's super quiet. He's the one that sneaks out and like wanders off. Like we always need to know where JP is.
Yeah, give him a car. Yeah. Give him a car and see what happens.
We've been seriously thinking about air tagging the child. He's the one that got out and Sam didn't know where he was for. Luckily, he was in the garage, but he's been known to, yeah. Saturday at the birthday party, Sam comes inside and he's like, "Do you know where JP is?" I said, "Yes." He goes, "That's good because I lost track of it." I said, "He is downstairs getting a new outfit because his clothes are upstairs." I said, "I realize that." He wants a big shirt. I don't know what that means. I'm covered in watermelon from your baby, so you're on your own.
I don't know. I used to, figure that like one gender was easier at the beginning and harder at the end, and it's so subjective as to the kid. My girls were pretty good. My girls were pretty well behaved early. And then when they got car age, they had problems with the car, just like every teenager, but but they really, and then I have friends who had boys who were really easy to deal with. And then when they got a car, they lost their minds. And then I had boys that were really, really difficult at the beginning. And then when they got a car, they got all this responsibility and they carried it off perfectly because the car meant something to them. Like, don't screw up the car. Don't I'm going to work for my car. I'm going to get a job. I'm going to get, and so you never know. You never know. You just don't know what the answer is going to be.
Owen was a super easy baby, but he is sassy pants now. He's not sassy with me, but he gets sassy with mom.
And that doesn't stop.
No, he got popped yesterday by me for being too sassy with mom. I was like, "You need to knock it out." She's trying. He goes, "Jackson is everywhere." And then my niece, she got him a Lego set that has 10,000 pieces and it's to build a race car. He's 8. He started reading the instructions. He goes, "Gigi, I don't think I'm to this level of reading yet."
Strive for something more.
I said, "Well, the good thing is that Dad will help you build this." I said, "Or Papa will, because Gigi does not possess the patience for this." He goes,
as long as those 10,000 pieces don't all end up on the floor.
"Yes."
Because then you're walking on Lego stuff.
Oh, that's better than any security system on the planet. Trust me.
All right, so we're on the record in docket TT 2301929, TT 240299763, and T0150030024. Forgot one. There's one in here.
The TV one.
Yeah, the TV 230126559. That is the City of Lansing versus Alana Callahan. This is the time set for a show cause on each one. It would appear I do not see Miss Callahan. This was set for 11:30. It is now 11:49. I do not see Miss Callahan in the Zoom courtroom. In the physical courtroom, Miss Callahan is not in the waiting room. It would appear that Miss Callahan has failed to appear for the show cause. There's a balance due on one ticket for $102. Balance due on the second ticket for $102. Balance due on the handicap ticket for $186. And a expired meter ticket for $90. So for the four different tickets, as I looked at the tickets, they're all written by different individuals. I'm going to issue a bench warrant and bond forfeiture. And that's all for the record on TT 230192129, TUT 4029763, TB 230126559, and T0150030024. So Miss Naviette, you're here for Empire Motors, is that correct? Or Miss Francis? Miss Francis, you're here for Empire Motors? Just saw her.
I am. Good afternoon.
All right.
Sorry, Judge,
And
could
we're-
you give me one moment? I'm so sorry.
Sure, and we're still awaiting Miss Ellison, is that correct? The defendant?
Yes.
All right. So yeah, if you're take your time and we'll wait. We'll give him till 2:15.
Thank you.
Okay.
I'm surprised he's not here. We're in transfer.
Oh, it's that guy.
Did he pay?
Mhm.
Maybe he paid all the money to you. Maybe you have all the money.
He actually paid it to Kelly. Because it's on the tech. I didn't have time to get it done.
Yeah,
Can
August
you use the
6th.
courtroom? Yeah, 'cause she was.
Sorry, Judge. I appreciate it. Thank you.
All
I'll
right,
just
you're all
hang
set.
tight.
We'll give Mr. Ellison did order a transcript of the previous hearing, and let's make sure that we give him the full 15 minutes.
Thank you.
You're welcome.
Just to clarify though, I don't think there was a hearing. Was there?
There was. They failed to appear.
Yeah, it was a fail to appear hearing, a motion hearing. Well, it was. We called the case, and that was on June 20th. We called the docket.
But we received the
And
order on our motion prior to the hearing, and so we didn't appear.
Let's see. I have, the hearing was held on August, let's see, that's not. Case was dismissed at last hearing, plaintiff failed to appear. And that was on the July 20th date. And you're
But we
saying
have-
it was,
Yes, we didn't appear because we got an order on our motion to set aside the payment order already entered by Your Honor, and it's dated June 20th. And so we got the hearings off and didn't appear.
yeah, I have the motion granted and writ of periodic garnishment may be issued. And then he filed an objection to the garnishment.
Okay,
That
I guess I'm confused.
Yeah.
Sorry, Judge. Could you give me one moment? The judge is calling me again
Sure.
on the other case. Sorry.
All right. Yeah, he filed more than one. He filed objections of entry of order on June 5th. I granted it on June 20th. So maybe I shouldn't have granted it. Because maybe we should have been working from the objection. Why would they do the motion and grant writ of periodic garnishment may be issued if he objected to it?
I don't know.
And then, I don't know who wrote this, DeAndre Ellis. This case was dismissed at last hearing, plaintiff failed to appear. And that's why he wanted. But they can set it aside. they can do whatever to set aside. I'll grant that. And then Mr. Ellison's just playing games.
Could be.
Is what's it set for today? An objection
Yep.
on garnishments that I've already set aside.
I didn't understand it, to be honest with you, but I really understand the civil side of things.
Well, then you should ask me then before, because we may not have it done. This may not have to needed to be done.
The transcript?
Yeah. Kelly did this, but I don't know. He's acting like, so this should be an order to set aside, or we can reschedule and renotice for objections to garnishment. Because I'll grant the motion to set aside. I don't know why the motion is granted and a writ of periodic garnishment set for a.
I'm sorry, I'm back.
All right, we might, let's give the required 15 minutes. I'm gonna call, Mr. Ellison may think that this is done. And what we may end up doing is resetting it for everyone for notice. But let me read through the file and see exactly where we're at, okay, ma'am?
Okay.
that was the same day as the court where he didn't show up.
So what is this writ of garnishment for July 3rd?
They filed and it got signed.
It got signed by.
I believe.
I'm sorry, Judge, whatever was said earlier, it was muted, so I didn't hear what was going on.
All right, let's go ahead and call this. And I think what you're gonna do is end up meeting with Mr. Ellison, but I wanna walk through what I have in the file, okay? Just because there seems to be some confusion. And one didn't make it to the file. One recent document. All right, so we're on the record in docket 2300132. That is Empire Motors versus DeAndre Ellison. Will the parties please indicate their appearance for the record? Ms. Francis.
Najat Francis, P72322 on behalf of plaintiff's attorney of record.
All right, Mr. Ellison.
DeAndre Ellison on behalf of myself.
All right, thank you. This is the time set, and this was set for I have for an objection, a previously scheduled objection. This is what I have in the file, and I think that may lend us some confusion as to what happened. So let me indicate that. I have the initial suit was filed for breach of contract, and that was filed in. The initial summons was January 23rd of 2023. And then I have an answer to that on March 1st, 2023. Then I have a pretrial statement on April 10th, 2023 involving the parties. Then we have an adjournment of trial. Then we have a civil judgment was signed on November 1st, 2023. Then there was a motion to set aside orders for installment papers. That was a motion from Mr. Craddockville on May 23rd, 2024, because the allegation was that the defendant was behind in payments. That's on May 23rd. Is that correct, Ms. Francis?
That's correct.
All right.
Judge,
Judge,
could you give me just one moment? My device is about to die. I'm trying to log in from another device.
All right.
I'm sorry.
Okay.
I'm in the waiting room.
Okay, I'm sorry about that.
All right. No, you're okay. Then, so I have that your motion was set on May 23rd. An objection was scheduled. Objection to that by Mr. Ellison was set for June 20th. And there's a certificate of mailing on June 5th of that date. On that June 20, then on that June 20th date, we had a hearing, and that was the fail to appear hearing. It appears that I don't have anybody here on that hearing, but Miss Francis, what you're representing is that I'd also signed by e-sign a motion is granted and writ of periodic garnishment may be reissued on that June 20th date, but it appears that nobody showed up on that date.
That's correct, Your Honor.
Is that a fair statement?
That is, we did not appear because we received the order saying that our motion was granted, which made the objections hearing set later for that day moot. So we did not appear, believing that the hearing was removed, Your Honor, because the order
it shouldn't. So I'm indicating now it shouldn't have been signed. It looks like it was signed on that date, on the June 20th date, which is the same date, because that's my electronic signature is June 20th. that's the same date as the hearing. The hearing was at 1:30 on the June 20th. So your indication is you received it that morning?
We received it earlier that day, correct? And so we canceled our appearance since the motion,
All right, well, let's.
motion was granted.
So, yeah, so this was the case was dismissed at last hearing for failed to appear, which I granted, and then that's when Mr. Ellison filed the well, that's why we're here. We're here on the objection. I think the objection's still valid. I don't think I should have assigned, and I don't know, why did you file a motion on so that this motion was in anticipation of the hearing? Because usually you file a motion after the hearing.
I'm not understanding, Judge, and I'm kind of confused. How can our case be dismissed if we already have a judgment entered?
Well, that's the problem, is that the judgment was sent the same day as the hearing, and you didn't show up because you thought the judgment was signed that morning. I'm asking, did you send in the judgment to be signed in anticipation of the hearing? Because you didn't sign in you can't have it both ways. You can't say we didn't show up because there was a judgment signed, but we sent the judgment in anticipation of the hearing. Does that make sense?
This was our order was.
It was signed on June 20th.
Correct.
Yeah, and that's the same day as the hearing. And
so I think, Judge, this was just an order, not the judgment. Judgment was entered back in November. I'm not sure if we filed the order or I have notes that we received the order signed.
All right. Well, I'm going to vacate the order. All right. So I'm going to vacate the previously signed motion is granted and writ of periodic garnishment may issue, and I'll do that order. That order will come from me. And then I'm going to let the parties figure out what a good plan is, because that plan obviously is not working, or it hasn't been working. But I think we can come up with a plan according to Mr. Ellison, but it sounds like there's a plan, there's an objection to the order. I think Mr. Ellison should be able to address his objections. I don't think that Empire Motors should be prejudiced in any way by them depending on the order that the court signed, saying that they don't have to show up. So I will vacate that order and then allow. So that's the first thing, is to vacate the order. We'll have to do that. And then Ms. Francis, I'll give you the opportunity to speak with Mr. Ellison, and you can come up with a new plan, so to speak, and follow that up, or not, and we'll just set it for a hearing on the objections to garnishment. We'll go on with the hearing, but it sounds like the objection. I'll read the objection in. The objection was, I have all intentions on complying to the payment arrangements. At the moment, I'm laid off, plus I'm being garnished 25% of each check, so I'm making less than my expenses. I ask that we keep the payment arrangement open to discuss new plans moving forward. I think that if the parties met, you can discuss any payment arrangements now and any payment arrangements in the future for Mr. Ellison. That would be the opportunity for the parties to meet. But I'm going to vacate. I'm going to vacate the order on the motion and granted and writ of periodic garnishment may be issued, because I don't think we'd had the hearing on the objections yet.
No, we haven't.
No. And then that would explain why Empire Motors didn't show up, because they relied on the order.
That's correct, Your Honor. We did rely on the order.
Right. So I don't think you should be prejudiced by relying on the order, but I don't think that Mr. Ellison should be prejudiced by never getting a chance to hear out his objections. And since we have everybody here, this would be a good time for both parties to meet.
Well, Judge, I would just argue that defendant hasn't made a single payment on the consent judgment that he signed. And those payments were supposed to start back in, sorry, December. In
December of
2023.
$100, December 15th of 2023.
Correct. He never made a single payment, and that's why we filed our motion to set aside that
Right.
payment order, because now he's defaulted. He's now 8 months later, still hasn't made a single payment. And so we filed our motion to set aside that agreement that he would have this reduced amount if he made those payments. He hasn't made those
Right.
payments. I'd be happy to discuss a payment plan on the full balance, but that's why we filed our motion, because that lesser amount is no longer valid.
That's completely understand. The payment, any payment amount that's discussed should be in relation to the entire payment that's been owed. I agree with that. It's just the timing of this makes it. Mr. Ellison didn't get his chance. He didn't get his chance to object because you weren't here, and you weren't here because you're relying on an order that I signed on the same day of the hearing that he had his objections. So the timing of this is messed up. I guess that's what I'm saying is that you didn't show up because I signed the order, and your order is correct. He has not made payments since December, but he also didn't get a chance to have his hearing because you weren't here, because you were relying on my order that was signed for his non-payment. So while we have everybody here, let's see if we can work through this. But you are right, Ms. Francis, that should, any new payment plan should be indication from what hasn't been paid since December of 2023. I think that's fair.
So Judge, I would ask that our motion be granted. However, I'm happy to discuss a payment plan with him on the full balance.
Well,
would be us. That would
right.
be.
I understand.
Sorry.
I understand your motion. I understand why you're asking it. I'm vacating my signature on vacating the motion for the writ of garnishment that I previously signed. And I'm really doing it because we never had a hearing on it. I think we have to have a hearing. I think Mr. Ellison has to be able to object. And it's just weird how the timing worked out that you're able to rely on the order for the hearing date of June 20th, that Mr. Ellison that actually his notice is a hearing will be held on June 20th at 1:30, which means that he never got his hearing. You relied on the order that was signed on that very day, that morning. So I think Mr. Ellison should have a hearing. So twofold, we'll reset this for hearing, or we can have the parties talk about something in lieu of that. And the easiest way to do that, Ms. Francis, is probably to put Mr. Ellison on some type of iPad arrangement so I can put you in a breakout room with him. And then if you need additional time, we can do that. But the party should speak on this.
Judge, since we're,
I think Mr. Ellison should have his hearing.
So, and since we're on the record and defendants, we're essentially going to enter into a payment agreement or a new payment plan.
Correct.
I think
because
I'm
going to sign an order indicating that I'm vacating I'm vacating my signature to set aside for installment payments, so Mr. Ellison can have a hearing and respond, because we never had a chance for the hearing. But you are absolutely right, Ms. Francis.
So I was just going to ask Judge if we could do this on the record so he can truthfully give us some information about his finances to see how much he can pay per month on that full balance.
How about this? How about I swear him in, and then you can have him in a hearing and you can discuss, and then we'll come back and put it on the record. Will that work?
That would work, Judge. I just wanted
I'm not caught. Then we can put whatever terms on the record. But I will swear you in, because it's essentially what we do in a creditor hearing is we swear them in. All right.
I just have a question.
Sure, Mr. Ellison.
Just for understanding, so you're vacating your signature, which means it will no longer be garnished.
Correct.
Time notice.
Correct. That's what I have here. Okay. And then, but in the same level, I'm only doing that for paper sequencing purposes, because that's kind of how. And then I'm going to have you meet with her. Okay. All right. All right. So I'm going to sign this. Well, I'll wait till the end to sign that. But I'm going to raise your right hand, Mr. Ellison. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm going to have you follow Miss Slabiak, and she's going to put you on an iPad. And then, Miss Francis, I'll place you in a room with Miss Slabiak, and then you can come out. We'll put it all on the record. All right, ma'am?
Thank you, Judge.
Your Honor.
All right. Thank you. So, Ms. Francis, what I'm going to do is I'm going to put you in room 1, and I'll put in the iPad in room 1, and then we'll put it all on the record with the agreement, and or if not, we'll set it for a hearing date, because that's probably something you want to do live, I would assume.
Yes, Judge.
Is that fair? Okay. All right. So, Ms. Francis, I'm going to put you in room 1, and then I'll assign the iPad to the same room.
Thank you.
You're welcome. And Mr. Cox, are you here for Terrence Hoskins or for Sparrow Hospital?
Sparrow Hospital, Judge.
All right, stand by. I'm going to call your case next. I think Mr. Hoskins is here, and that's set for pretrial today. And but stand by, give me 1 second. I'm setting up somebody else in a breakout room, but they happen to be on iPad, and so we're going to put them in a room. So give me 1 minute.
Okay.
All right, so we're on the record in docket 23-06045. That's Edward Sparrow Hospital versus Terrence Hoskins. And Mr. Cox, your appearance for the record.
Yeah, good afternoon, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
And sir, you are Terrence Hoskins, is that correct?
Yes, sir.
All right, the time is set for a pretrial in the matter. And since I have you both on Zoom, this pretrial, that's what I have it as a pretrial. Is that your understanding, Mr. Cox?
Yes, Your Honor.
All right. So we can do this 2 ways, 2 or 3 ways. Normally what I do is allow the parties to speak, and I can put you in a breakout room. So Mr. Cox and Mr. Hoskins, you can talk about whatever the pretrial, and then I would give you the opportunity, Mr. Cox, if you want to, since you're a lawyer on this, to submit a pretrial statement that Mr. Hoskins has signed on to, and you could discuss some of those matters and then follow it up with a submission, or we can just do it on the record, a pretrial on the record. Either way, I'd give you the opportunity to speak to Mr. Hoskins if you choose to. That's up to you, Mr. Cox. So how would you like to proceed today at this pretrial?
Yeah, I've not spoken to Mr. Hoskins yet, so I would like the opportunity to speak to him in a breakout room. And then depending on how things go, sometimes going on the record, frankly, Your Honor might do a better job of explaining things like discovery and witness exhibit lists than I might, but we'll see. All right. Why don't we give it a crack in the breakout room and then go back on the record, and then we'll advise the court whether we want to submit a joint pretrial statement or have the court do one for us.
That sounds great. So, Mr. Hoskins, this is a pretrial. I'm going to put you in a breakout room with opposing counsel, who's Keith Cox. You'll get a prompt to go to room 2, and then we're going to bring it back and we'll put it all on the record. And if we want to do the pretrial on the record, we'll go ahead and do it at that time. All right, Mr. Hoskins?
Yes, sir.
All right. So, Mr. Cox, you will get a prompt to go to room 2. And Mr. Hoskins, you will also get a prompt to go to room 2.
Thank you, Judge.
I'm going to say, and then we're going to go to Mr. Dowrick. Mr. Dowrick and Mr. Kazort, you can come up here. juggling. Got a lot of things in there. Mr. Hoskins, is he joined yet?
Looks like it.
All right. So Mr. Hoskins, you can join that breakout room, or that'll be room, I believe that was room 2. Yeah, Mr. Cox is waiting for you in room 2. So you can go to join room 2. So we're on the record in docket 2402501. That is Todd Dowrick versus Kayla Goodell. Will the parties please introduce themselves for the record? Mr. Kazort. I'm sorry, Mr. Dowrick.
Todd Dowrick.
Mr. Kazort.
Adam Kazort here on behalf of Ms. Goodell.
All right, this is the time set for a non-payment hearing, and Mr. Dowrick, it's my understanding, how are we proceeding today?
We have a consent judgment prepared.
All right, and Mr. Kazort, is that a true statement? And did either party want to place any terms on the record?
That is accurate, Your Honor. Mr. Dowrick has it here, but I will put the terms. Your Honor, we have a consent judgment with a possession judgment amount of $3,591.28. There is also a money judgment. The amount of the money judgment is $2,704.18.
And if you, is that the order right there? If you provide that, yeah, I will place that on the record. Thank you. So I'm in possession of the consent judgment for 2402501. This has, as indicated by the attorney Adam Kazort, a $3,591.28 total possession judgment. Honor, the 4A is checked for on or about August 16, 2024. 5 and 6 are checked. 6 will not prevent a partial payment, will not prevent order evicting the defendant. And then the money judgment, I'm assuming for the lesser amount or prorated amount of $2,704.18. Mr. Dowrick, is that your understanding of the consent judgment?
Yes.
All right. And Mr. Kazort, there's nothing on here that either party didn't agree to.
No, nothing that we didn't agree to.
Is there nothing that you didn't agree to?
That was an odd phrase.
You agreed to everything, didn't you?
I agreed to all of it.
Let's keep it without the double negatives in touch. Both parties have signed the bottom of this. Is that fair?
That is correct.
All right. There is a court rule out there. Mr. Kazort's an attorney. Mr. Dowrick, you understand that because there's no representation today, that you have 3 days from today's date to say whether something we did here was ambiguous or not ambiguous, since you're not represented by counsel. But you were in this court enough to know what this means, right?
Yes.
That's okay.
You've done 1 or 2 of these, right?
Yeah, you've done a couple of these in the past.
I filled it out.
Yeah.
It's true.
I will set the appeal date for the same time period. And then I will sign it accordingly for the judges, for the parties. That's for 8/6/2024. I will sign that. And then we will scan and make sure it is in the electronic file and give a copy to each party. All right.
Thank you.
Anything else for the record in 2402501, Mr. Dowrick?
No, sir.
Mr. Kazort?
No, Your Honor. Thank you.
Thank you. It's good to see both of you. Thank you for your appearance today.
We're quicker this time.
Yes, you were quicker this time, but I had plenty going on. Mr. Hoskins is back. I don't know when he left, but.
You know, it does not feel bad out. Not with the race.
Yeah, it's supposed to cool off now.
I can stand to walk here with my jacket on, so.
All right, let's put Mr. Hoskins in room 2. All right, so Mr. Hoskins, are you there?
I'm here. Yes, I am.
All right, I'm gonna place you in.
And I'll try to.
Mr. Cox, did you have the opportunity to speak with Mr. Hoskins?
No, our connection was poor. Mr. Hoskins kind of faded in and out every other word, and then he left the room, came back 2 or 3 times. So the only exchange we had is, can you hear me? Can you hear me? And
All right, that sounds like a similar experience with Mr. Hoskins, because Mr. Hoskins, are you there? You're breaking up on your Zoom connection, and the only thought I have now is whether this technology is really working for you, because this isn't the way to have a pretrial. You may end up showing up live. Mr. Hoskins?
Oh, yes. Can you hear me? Or
We can hear you now. Okay, we can hear you now. Did you want to give the breakout room
okay,
another try,
I hear
Mr.
you guys.
Hoskins?
Yes. Would it be possible I can give him my phone number and he can just call me and then we can rejoin the Zoom? Will that work?
Sure, Mr. Cox. If he provides a number, you may be able to use that as a secondary way of communicating with him.
yeah, sure. I'm happy to speak to him. I have a number in my system. I don't know if it's the correct
All
one,
right.
but
Mr. Hoskins, what's a good contact for you right now?
One number is well, you can call me at 517-490-3807 because I was 517-490-3807.
That's the number I have.
The number that you have, I'm actually using that phone for the Zoom meeting, I believe.
Well, the one I have in my system is the one ending in 3807. So
all right.
Okay, that's
so
it. You can call me on that one.
Why don't we do this? Why don't you can both contact your number, Mr. Hoskins, if you have to leave, and then come back and we'll put it on the record. That might be an easier way for you to have any type of private conference. Does that work for you, Mr. Cox?
Sure, I'm happy to give him a call.
All right, so Mr. Cox is going to give you a call, Mr. Hoskins, and then if you have to leave, rejoin the Zoom room, and we'll put it all on the record. Okay.
Sounds good. Sounds good.
Okay. All right. So I'm gonna let both of you go, and then you can rejoin, and we'll put it on the record.
Okay.
All right, so Mr. Ellison. All right, let's go. No worries, no worries. All right, let's go on that case now that you've had the opportunity to meet with Ms. Francis, and then we have another case that's pending. So we're on the record in 23-00132, and Ms. Francis, did you have the opportunity to meet with Mr. Ellison in a breakout room?
I did, Your Honor. We did come to an agreement. Sorry.
Okay, so go ahead and state the terms on the record.
We have agreed that defendant will pay on the full balance of the judgment, $900 by 9/30/24, and then $150 per month after that, by the end of each month, beginning October.
All right. All right, and was there anything in what Ms. Francis indicated that was not a part of your agreement, sir?
No, Your Honor.
All right. And Ms. Francis, you'll follow that up. I'm almost afraid to say this, with an order to the court for the court to sign in relation to the agreement that was made?
Yes, Judge, I did have a question though. Do you want that to be a stipulated order? Like, do you need us both to sign it or just submit it since we put it on the record?
Yes. So, Mr. Ellison, Ms. Francis is asking a good question here. If it is a stipulated order, that means that you would give your authority to her to sign the order on your behalf based on what was placed on the record.
Yeah, we spoke on that in the breakout room. I told her I would like to be a part of anything being filed to the court.
All right, so this is your chance to be a part of that.
Yeah.
If we were on the record, she's placed the agreement understanding. If that is your understanding, do you give Ms. Francis your authority to sign on your behalf?
Understand like that, yes.
Okay. All right, so and then she'll send you a copy. She'll email you a copy, but that gives you the authority to advance that to the court for the court to sign. You'll also get a copy of my signature on the court order, but she'll send you a courtesy copy since you've agreed, okay?
Thank you.
Is that a fair statement, Ms. Francis?
Yes, Your Honor.
All right. So order to follow for court signature. Just for the party's recognition, I have officially, just so there's no, because that's where the order was signed on the same date as the hearing. I vacated that initial order. Plaintiff's order to set aside pay, order granting motion to set aside for installment payments and writ of periodic garnishment signed on June 20th is vacated. I did an order to that just to vacate that. So that should set this agreement not only chronologically correct, but also paperwork wise, it should comport with anything we've done today.
Can I also get a copy? I have to give to my employer to make sure they know.
You can get a copy of the order, yes. All right. So we'll make a copy of that. And then Miss Francis, we can send you a copy also of the order. It'll be in the file.
Thank you, Judge.
Okay. Anything else for the record in 23-00132 GC, Miss Francis?
No, Your Honor.
Mr. Ellison, do you have any questions of me today?
No, Your Honor.
All right. We'll make sure you have a copy and send a copy. Do you want it sent? You want it sent to the Craddockville Law Firm, Miss Francis?
Yes, Judge.
All right. All right. All right. With that understanding, thank you everybody for your appearance. You're all set. Okay.
And now we get that copy where?
Right today.
Okay.
Right today.
All right. Thank you.
Thank you, Miss Francis.
Thank you, Judge.
All right.
Did you say I had another pending trial room or that was somebody else?
No, we were talking about a different case.
Yeah, that was a different case.
I was like, what's
you're only here on this file, one at a time, right?
Right. I said, I promise you I didn't do it.
Yeah. All right, so Mr. Cox and, we lost Mr. Hoskins. Mr. Cox, are you there? Saw you on the phone. All right, so we're back on the record in docket 2406. I'm sorry, 23 06045. That's people state Edward Sparrow versus Terrence Hoskins. And Mr. Cox, did you have the opportunity to speak with Mr. Hoskins concerning this pretrial?
We did, Your Honor. I believe we had a productive conversation. I made him a settlement offer. He made a counter offer that fell below the authority I have for this afternoon. Emailing my client with regards to that offer. It's a lump sum offer that may well dispose of the case in its entirety. Obviously, we could go through the court's proposed procedure with a pretrial order today, but we discussed just the possibility of maybe adjourning this out 30 days. I've got his email address. In the event we do accept his proposal, we would just simply stick to a dismissal of the claim without having to do a pretrial order. But obviously, if the court proceed differently, we can do that. But that was my thought, because I think we're close. I suspect we'll probably work it out in the next 30 days.
Let's do that. Let's keep this, and so we'll adjourn the pretrial for negotiations to continue. And what I'm going to do is we'll go ahead and set it, which I don't know. They may not want us to, but if we do it, at least we know when we're setting it for. So we'll set it for 30 days out for continuation. And then if 30 days out, if it's still negotiating, we'll do the pretrial statement and we'll continue on.
Right.
But we'll set it for 30 days out and wait to hear from the parties. Mr. Hoskins, is that what you're in agreement with? Are you in agreement with setting this out 30 days to have negotiations continue?
Yes, sir.
All right. All right. So we'll get a date 30 days out of
September 10th at 1:30.
September 10th at 1:30.
Works for plaintiff.
All right. Well, so adjourn pretrial for continuing negotiations, and we'll set it for September 10th at 1:30. You will both get notifications sent to you from the court at your last known address. Anything else for the record in docket 23-06045, Mr. Cox?
I just want to let Mr. Hoskins know the ball's in my court, and you'll be hearing back from my office very shortly.
All right. Thank you, Mr. Cox. Mr. Hoskins, do you have any questions of me?
No, I do not.
All right. You're all set. Thank you for your appearance today. You're all set.
All right.
Thank you, Judge. Thank you, Mr. Hoskins.
Thank you.
I know sometimes I get it. I mute.